In August 2019, it was revealed that a team calling itself the Artificial Inventor Project had filed 2 patent applications for inventions developed by an AI system known as DABUS. The 2 inventions have since been rejected for patent protection by the UK IP Office, the European Patent Office, and the USPTO. Appeals have been filed, while applications in other jurisdictions are still in the pipeline. In this presentation, I'm going to discuss whether machines can invent or do other creative things. Spoiler alert, I don't think that they can, at least not yet, and not in the sense required by patent laws. But I do think that there are emerging issues around the implications of AI for patent law and practice that are far more pressing than science fiction concerns about creative computers. So here's what's on the agenda for this presentation. First, I'm going to introduce the Artificial Inventor Project, which was responsible for the recent patent applications naming a machine as inventor. To give you some context for this, I will provide some basic background on machine learning and describe some of the recent work on machine creativity within the mainstream of AI research and development. I'll then talk about the supposed AI inventor DABUS, the inventions disclosed in the applications, and the most recent developments in the whole saga. Finally, I'll try to bring the presentation back down to earth by discussing some more pressing challenges AI technologies present for patent law and practice. Okay, the Artificial Inventor Project. The leader of the project is Surrey University Professor of Law and Health Science, Ryan Abbott. The project website also identifies 12 private practice patent attorneys registered across 11 jurisdictions as members of the project team. The DABUS AI itself was created by Dr. Stephen Thaler. However, he is not himself identified as a member of the project team. By his own account, Dr. Thaler appears to be something of a polymath. The only thing he seems to be missing is a formal qualification in either computer science or software engineering. Professor Abbott's thesis is that patent laws should recognize machine inventorship. He doesn't suggest that machines should be granted legal personality or the right to own property. Patent rights to machine inventors would, according to Professor Abbott, automatically vest in the owner of the AI. Abbott argues that recognizing machine inventors would serve the policy objectives of the patent system by providing an incentive for the development of creative machines. I can't say that I necessarily agree with this proposition, and I find it hard to imagine any economist accepting that a novel form of patent incentive is necessary for the development of machine inventors. Even without patents, such a machine would be like the goose that lays the golden eggs. We'll come back to this, but here are the front pages of the 2 applications as published by the European Patent Office. If you look closely, you'll see that the inventor fields each state that the designation of the inventor has not yet been filed. The EPO online systems don't permit the naming of a non-human inventor, so DABUS's details were filed separately, which triggered proceedings to reject the applications. But as I say, we'll come back to this. So let's look at some basic principles of machine learning. For those allergic to equations, I'm afraid there are a few in this section of the presentation, but I'm going to keep it as simple as possible, and hopefully you'll manage to follow along with pictures, even if maths is not your strong suit. I'm going to explain the technology by reference to a high-level model that broadly represents the overwhelming majority of applied machine learning systems. These kinds of systems generally have some real-world inputs that consist of raw data in the form of something like position, speed, size, value, words, sentences, images, pixels, depending upon what the actual application of the system is. The first thing we need to do is to take that raw data and convert it into some sort of numerical representation which is useful for the computer to be able to learn from. These numerical representations are often called features within the profession. These features are input to some sort of parameterized function, which is at the heart of the machine learning system. There are many options for these parameterized functions, including neural networks. The output from the function is some sort of value or values that, again, tells us something that we can use in the real world, depending on the application of the system. The main thing I want to focus on for the purposes of this discussion is the idea that at the core of every machine learning system is some sort of parameterized function. So what do I mean by a parameterized function? Well, let's suppose we have some process that can be described as taking some number of inputs, and we'll call that number n, and producing some number of outputs, and we'll call that number m. Then we can try to model that process by some function f that's characterized by a set of parameters. Here the number of parameters is denoted by k. Okay, maybe this is all still a bit abstract, so let's look at a really simple example. If you studied some statistics in high school, you may be familiar with simple linear regression, fitting a straight line to a set of observed data points. This is a basic parameterized function with two parameters. In the interest of inclusivity, I've chosen a hypothetical everyday example to illustrate this. Imagine we're looking at the prices of real estate in a particular region, and we believe that the biggest factor contributing to value is the area of the property. So we gather some data from recent sales, including the land area and the corresponding sale price. And we fit a straight line to the data. This is a model of house prices in the region, which can be characterized by two parameters, the axis-intercept and the gradient. Specifically, we can write an equation for this in the form shown in the previous slide. We have n equals 1 input variable, that's x0, and we have m equals 1 output variable, that's y0, and we have k equals 2 parameters, p0 and p1. In the machine learning context, we would say that our objective is to find p0 and p1 such that the model is a good fit to the observed data and has good predictive power for unseen data. So let's now talk about neural networks. Neural networks represent more complex functions, but the principle is the same. Suppose we have two inputs, which in our simple neural network are provided to what we call an input layer. Inside the network is something that we call a hidden layer. The inputs are each multiplied by a set of numbers, which we call weights, and the resulting values are passed to the hidden layer. Finally, we have an output layer, which receives similarly weighted values produced by the hidden layer. Each of the circles in the network, often called nodes or units by practitioners, performs a simple calculation on its inputs, adding them up along with an additional constant value, which is a bit like the axis-intercept in linear regression, and then passing the result through an activation function, which generally converts this number into a value varying between off, for example 0, and on, for example 1. The general idea here is that when the inputs are strong enough, the node will activate. All of those weights and constants are effectively the parameters of a function that is represented by the neural network. Here, the goal is to find the values of the 21 parameters, including the weights and the constants, such that the output most closely matches the observed data. So we say that this particular simple neural network has 21 trainable parameters. Okay, let's make this more concrete. Here we have a more realistic example which addresses a practical problem in machine vision. Can we teach a neural network to recognize handwritten digits, such as postcodes on envelopes? For this example, we assume that our inputs are images of handwritten digits which have been scaled to 28 by 28 pixels in size. There are 784 pixels in such an image, and therefore we can construct our neural network with 784 inputs, that is 1 per pixel. Generally speaking, we can choose the size of our hidden layer, and in this case, 32 hidden units have been chosen. This means that with 784 inputs for each of 32 hidden units plus their internal constants, we have 25,120 weights connecting those inputs to the hidden layer. For the output layer, we choose to have 10 distinct outputs, one for each digit, 0 to 9. This means that we again have a further set of 330 weights, being the 32 connections from the hidden units to the output layer units, plus the constants within those output layer units. If we add all of those up, we can see that we have n equals 784 inputs, m equals 10 outputs, and a total of 25,450 trainable parameters making up our parameterized function. The goal is to try to find the values of those parameters so that when the input image is a 6, the output corresponding with the digit 6 is activated, and the other outputs are effectively not activated. In practice, this architecture can be trained to achieve at least 93% accuracy on a well-known dataset comprising 70,000 samples of handwritten digits. So how do we go about finding suitable parameters, especially when the number is so large? In real-world machine learning applications, there are way too many parameters and too many data points to directly compute a global optimum, as you may have done with simple linear regression in a statistics class. Instead, we use algorithms that try to search for good parameters. Suppose, for example, our goal is to decide whether or not a photo includes a cat. So we have some photos which either include cats or don't include cats, and those are our known inputs. What we're trying to do is to train this system to give us an output that tells us the probability that there is or is not a cat in the input. Okay, so with our training data, where we've got a whole lot of images and labels to indicate whether or not they contain cats, we know what the output is expected to be. We can then put an input into this system, observe the output, compare it with what we expect, which is the target, and then work out whether we were right or wrong, or indeed how close we were to being right or wrong. From this, we can provide feedback into the parameterized function that can be used to update the parameters to try to get a better result next time. Training, then, is the process of repeatedly performing incremental updates to the model parameters using samples from the training data until we reach a point where the overall loss across all of the data reaches an acceptable minimum. If we do this carefully, then when we provide the model with images it has not seen in the training set, it will, hopefully, correctly detect the presence or absence of cats in most cases. It turns out that that's pretty much all you need to know to understand how a machine might be trained to emulate creativity. But before we consider whether machines can invent, let's look at whether they can alter copyright works. Unlike inventorship, there's quite a lot of published, peer-reviewed and open-sourced work on this branch of what we might call machine creativity. Most efforts to emulate creativity, since around 2014 at least, have been based on a structure called a generative adversarial network, or GAN. The idea is not too hard to grasp and starts with something not unlike the cat detector system. Suppose we have training sets of real images and fake images. Then we could input those to some sort of discriminator that's intended to distinguish between the real and the fake. In this case, the discriminator is something called a deep neural network, which really just means it's a neural network with a larger number of hidden layers. We can train that neural network to better distinguish between real and fake. The clever move in the development of GANs was to ask, what if we use a second machine learning model to generate the fake images? Then we could try to train the second model to fool the first one. That's where the adversarial part comes in. So now we have two processes going on. First, we're evaluating images to try to discriminate between real and fake. Second, we're optimizing both the ability of the discriminator to tell the difference and the ability of the generator to produce convincing fakes. If you've ever heard the term deepfake, this is where that comes from. So does optimization plus evaluation equal creativity? Not, I would argue, in anything resembling the way that true human creativity works, but in some cases it can produce a surprisingly effective imitation. In October 2018, a computer-generated artwork went under the hammer at Christie's in New York. Just to be clear, this wasn't a stunt or a work of performance art like Banksy's self-destructing Girl with Balloon. Prospective buyers knew the true nature and provenance of the work, that is, that it was created by a machine. This is what the work looked like. And if this wasn't a recorded presentation, I could ask for your guess on what it sold for. But in the circumstances, I'll just have to tell you that it was an eye-watering $432,500 US. If you look closely in the bottom right-hand corner, you'll see that in place of a regular signature, it has an equation. This signature is a representation of the GAN optimization problem. We can see from this that the goal of the discriminator D is to maximize the value of the expression. That will happen if it correctly identifies real paintings, the X's here, as being real, so D equals 1, and fakes, the Z's here, as not real, that is D equals 0. The generator, on the other hand, is trying to minimize the output, and that will happen if it can fool the discriminator into making it output a 1 for a fake painting. It's telling that the artist collective responsible for the work, aptly named Obvious, identify various ways in which they experimented with different configurations and inputs in order to achieve their objective, which was to show algorithms emulating creativity. They've not abdicated the role of the artist to the machine. They clearly see the machine as a new instrument for creating art. The next evolutionary step in this area was creative adversarial networks, a modification of GANs developed in the Art and AI lab at Rutgers University. The modifications that the researchers made to the GAN objective were designed to maximize what we might call novelty while maintaining the property of looking like art. While the verbal description sounds a bit nebulous, the paper itself is mathematically rigorous and includes a specific adaptation of the GAN loss function that captures this notion of novelty in style. Again, the human developers and artists are not looking to credit the machine with artistic intent, but rather view it as a new medium for art. So all of what I've told you so far summarizes a mainstream perspective on machine creativity. The so-called Artificial Inventor, DABUS, which stands for Device for the Autonomous Bootstrapping of Unified Sentience, shares some features with GANs and other well-publicized machine learning approaches, but it is not mainstream. Its developer, Dr. Stephen Thaler, describes it as a new neural network paradigm that seems to be based on his own unique theories of cognition. The description of DABUS that appears on the website of the Artificial Inventor Project sounds very much like a GAN. But on his own website, Thaler expressly denies that DABUS is the combination of a generator net with a discriminator for distinguishing real from fake. He also claims that he invented and patented the GAN approach long before it was developed by Ian Goodfellow and colleagues at Google Brain in 2014. DABUS is the subject of a recently issued US patent. Here's the main drawing from that patent. The top part represents a form of interconnected neural network where the nodes are arranged in a grid and their current state displayed as the color or intensity of pixels on a screen. These are captured using a camera. Don't ask me why the information is not just transferred in memory or via a data link. And then input to a Thalama bot. And please don't ask me what a Thalama bot is. The Thalama bot performs some sort of vaguely described magic to identify novel features in the display image and feeds back reinforcement signals to strengthen novel structures and noise to randomly break and remake connections in the neural net. Don't ask me why or how this works. Here is Saylor's graphical representation of how DABUS operates from his website. It's prettier than the patent drawing, but not much more enlightening, I'm afraid. I should point out that the weird display and camera interface arrangement and the term Thalamabot, which Saylor claims as a trademark, both appear in the patent's independent claims. For those unfamiliar with details of patent law, this means that using a camera in this way and employing a Thalamabot are both essential elements of the patented invention. Variations that omit one or both of these elements do not fall within the scope of protection of the patent. So, what did DABUS allegedly invent? The first invention is a generally cylindrical food or beverage container whose walls have a fractal profile. There's the drawing, and there's the corresponding patent claim to the structure. This might well be novel, but what are the advantages? They're said to include the ability for the containers to lock together for packing and transport, increased surface area for heating and cooling, and easier gripping. I'll let you judge for yourselves whether this is a product that the world is crying out for. The second invention is a form of electronic flare that flashes at an average rate of around 4 Hz, but with a kind of fractal pattern. And here's the claim, and here's a flowchart describing that method of flashing the flare. Again, while this might well be novel, what are the advantages? Well, the 4 Hz supposedly has something to do with a natural rhythm of brain activity, while the fractal variations supposedly capture attention more effectively than a regular periodic signal. The evidence that this arrangement attracts enhanced attention appears to lie in Saylor's own theories of cognition. So how does this machine inventor work? How are concepts as disparate as beverage containers and flare patterns represented? What do the environment inputs to DABUS look like? Don't ask me. You can try reading the explanation for yourself, but if you can make any sense of it, you're probably a smarter person than I am. Saylor has apparently anticipated a number of potential criticisms of his work and addressed them in frequently asked questions on his website. Why does he not publish like other leading AI researchers? Well, the answer to that is that he has a patent which has been approved by totally unbiased subject matter experts, otherwise known as patent examiners. And he's not one of those ivory tower paper writing academics. But what about his unique theories of consciousness? Well, it's all mathematically rigorous and fractal. And why is DABUS obsessed with fractals? Well, apparently the answer to that seems to be that it's been spending too much time with its dad. Saylor is also a subscriber to the theory that there is a close relationship between mental illness and creativity. Not surprisingly, therefore, DABUS is also capable of experiencing mental health problems. More surprisingly, a reporter at Wired was able to report on this with an apparently straight face. Compared to the mainstream research community, the way Saylor describes his technology is very non-technical. AI and machine learning research these days is highly mathematically rigorous. Researchers expend a lot of effort on trying to prove things like whether various optimization algorithms are guaranteed to converge to a local minimum, and how patterns in the inputs are captured within the data structures of the machine learning models. Being able to explain how machine learning systems produce their outputs is important, for example, when they're used in autonomous vehicles or to assist in making administrative decisions. And there's at least one other area in which Thaler seems to have avoided one of the problems that's starting to challenge the mainstream. Modern, state-of-the-art machine learning, enabling machines to perform human-like tasks such as natural language processing, is enormously costly in computing resources. It doesn't matter whether you buy your own computers or rent them in the cloud. By the time you've experimented, developed, and finally trained a working model, you will most likely have spent tens or hundreds of thousands of dollars on computation or on hardware and electricity. Thaler wants us to believe that he has bypassed or solved practical problems in implementing advanced AI systems that are currently occupying the minds and budgets of many of the world's leading researchers and corporations. I think we need to keep in mind the standard that Carl Sagan set when he said that extraordinary claims require extraordinary evidence. Thaler seems unwilling to provide this. Rather, from reading his website and information that he's provided, presumably for the Artificial Inventor Project, obfuscation is more his stock in trade. Putting aside my obvious skepticism about DABUS's abilities as an inventor, the Artificial Inventor Project is forcing patent offices to make decisions about whether or not to permit non-human inventors to be named on patent applications. The problem for patent offices is not whether or not to accept the assertions of machine inventorship, but rather assuming them to be true whether or not the applications are valid. So far, at the time of this recording, the UK Intellectual Property Office, the European Patent Office, and most recently the US Patent and Trademark Office have all issued decisions on this matter. The UK IPO has determined that an inventor must be a natural person. Notably, they followed their office practice of accepting the identification of the inventors at face value. That is, they accepted that DABUS created the inventions on the basis that that's what the applicant had told them, not on the basis of any deeper investigation. DABUS is a machine and not an actual person, and therefore can't be regarded as an inventor. The UK IPO also determined that even if a machine could be named as an inventor, ownership of that machine would not be a basis for entitlement. So the applicant would therefore not be entitled to apply for a patent. As an Australian practitioner and looking at similarities in the language of the relevant legislation, it's interesting to me that the same issue would presumably arise under Section 15 of the Australian Patents Act. The EPO also ruled that an inventor must be a natural person. It took a broader view than the UK IPO, considering the consequences if the full range of rights enjoyed by human inventors were extended to machines. The fact that a machine has been given a name does not change the position. Thaler has appealed, although I don't like his chances. The USPTO has also issued an adverse decision on the corresponding applications. Firstly, it found that the patent statutes imply that the inventor must be a natural person. Throughout various sections, language is used that creates this implication, and interpreting an inventor to include machines would contradict the plain reading of those sections of the legislation. There's also Federal Circuit precedent that was cited by the USPTO, which found that the state couldn't be an inventor because inventorship requires conception of the invention, which is a formation in the mind of the inventor and a mental act. Finally, although Thaler argued that because DABUS was itself patented, its invention should also be patentable on its behalf, was rejected. The USPTO said that that was not true any more than it was true that a patent for a camera should allow the camera to hold a copyright. As for Thaler's chances of succeeding on appeal at the EPO, a big problem here is that even before having to deal with the DABUS inventions, the EPO had foreseen a range of issues that might be raised by AI technologies and commissioned a study on inventorship in inventions involving AI activity. That study reviewed the legal position in a number of leading jurisdictions and concluded that machines could not be identified as inventors in any of them, which, as we can see, is proving to be true, and that it would be premature to consider any change to this position at this stage. Even so, something that was at best a fringe idea just a couple of years ago has been gaining traction within major IP organizations. Over the past year or so, both the World Intellectual Property Organization, WIPO, and the USPTO have been engaged in consultations on the interplay between AI and IP systems. WIPO in particular appears to have been persuaded that inventions already can be autonomously generated by AI. The USPTO has taken a more cautious line, assuming nothing but asking whether there is any need to consider changes to inventorship laws and regulations. Responses to their consultation suggest that there is a very strong antipathy and constitutional objections to allowing non-human inventors in the United States. There were many responses to the calls from both WIPO and the USPTO, and you can go and read them all if you wish. Notably, however, most of the powerhouse AI and machine learning developers did not respond. There's nothing from Microsoft or Google or Facebook or Amazon or OpenAI or DeepMind, for example. I just want to highlight a couple of responses that did come from organizations that you might expect to have a deep understanding and interest in the issues. Firstly, IBM's submission to the USPTO, in which they expressed the view that it would be a considerable time before machines are able to invent independently. Secondly, the IP Owners Association, whose members include Microsoft, Google, Apple, Oracle, and IBM, essentially called WIPO out on its bald assertion that it is clear that inventions can be autonomously generated by AI. IPO suggests that WIPO needs to define what it means by autonomous and avoid accepting contentious claims as fact. To be clear, I'm with IBM and the EPO's consultant, Dr. Noam Shemtov, in thinking that we have a long way to go before a machine will truly be capable of autonomous invention. But to finish up, I want to bring the discussion back down to earth with some more pressing issues that AI creates for patent law and practice. Firstly, subject matter is an issue, given that AI and machine learning inventions are inherently software implementations of mathematical algorithms. While some offices, including in Australia, are relying on their general practice in relation to computer-implemented inventions, the European Patent Office has added a specific section to its guidelines, including a number of examples. So, for the use of a neural network in a heart monitoring apparatus for the purpose of identifying irregular heartbeats, the office says that would be patentable, presumably because it's a heart monitoring apparatus. Classification of images, videos, audio, or speech signals based on low-level features, like edges or pixel attributes for images, is also considered to be patentable subject matter, presumably on the basis that it's technical. However, classifying text documents solely according to their textual content, or classifying data records without any indication of a technical use being made of the resulting classification, are not considered patentable subject matter according to the guidelines. As always, the EPO is looking for technical character. Mere information or its generic manipulation will not support a patent. The EPO also indicates that methods of training, and even of generating suitable training data may contribute to technical character and therefore to patentability. On the question of inventive step, the advent of more powerful tools to assist inventors may present challenges to patent offices and courts. While using tools in the process of innovation does not in itself preclude finding an invention to be non-obvious, because, as the US statute says, for example, patentability doesn't depend upon how the invention comes about. The use of advanced AI or machine learning tools is increasingly common practice in some fields. If we look at the Australian law, for example, the test requires us to look at what the non-inventive person skilled in the relevant field would have done to address a given problem. Once that person can be assumed to have access to a machine learning system that would inevitably progress their work from the prior art to the alleged invention, what will that mean for inventive step? There are also questions emerging regarding the disclosure requirements for inventions involving advanced AI and machine learning systems. To my knowledge, the Japanese Patent Office is the first to have set out guidelines and examples to explain their practice in this area. Here are some of the examples in their examination manual. Notice that when I use the term based on here, it means that a machine learning model has been trained to generate estimates using the specified input data. So in one example, estimating sugar content of vegetables based on facial features of growers is considered not to be supported by the description, because the idea that what the grower looks like, as opposed to anything they do in relation to the growing of the vegetables, might contribute in some way to determining the sugar content is simply not credible to the person skilled in the art. A system for planning production quantities of goods based on web advertising data, on the other hand, is considered to provide a sufficient description because the person skilled in the art can assume that a correlation would exist between people seeing ads on the web, for example, and the quantity that end up being sold of the products. A system for prohibiting manual control of an autonomous vehicle using reaction speeds estimates based on driver images is also considered to be sufficiently described because the person skilled in the art can presume that a correlation would exist between information you can obtain by taking images of a driver's behavior and their reaction speed. In a slightly more complex example, estimating weight of a person based on features of their height and face shape, when broadly claimed, is not considered to be enabled by the description because in that case the face shape features were too generic and didn't teach the skilled person exactly what aspects of face shape might be required and correlated with weight. However, a dependent claim which referred to specific face shape features that were described in the specification was considered to be enabled because it was more apparent that the correlation would exist. The Japanese Patent Office approach creates a potential trap for applicants. For a correlation to be credible, it must be apparent to the person skilled in the art in light of the common general knowledge that that person possesses. That means that something which is credible on the face of the description might also necessarily be obvious because it's effectively known. Care will therefore have to be taken in drafting specifications for inventions where the inventive step resides in the discovery of a non-obvious correlation. Another problem arises in meeting requirements for enablement of complex machine learning models. It might be necessary to provide a full description of the models themselves and the features employed in order to use as inputs. It may be necessary in order to reproduce the model to have access to suitable training data. It may be that in order to verify and deploy applications of the models, actual trained models themselves might need to be made available. In the context of research publications, where the ability for other researchers to validate and reproduce results is considered essential, the gold standard has become open sourcing of training data and code, as well as making trained models available for download and use. Arguably, a machine learning model may not be enabled without full disclosure of implementation and training details and availability of the training data. And an application of a machine learning model may not be enabled without the ability to reproduce or obtain the trained model itself. So should there be some form of deposit requirement for inventions involving AI or machine learning? This has been raised, in fact, by WIPO in its ongoing consultation on issues relating to patents and artificial intelligence. So to sum up, can machines invent? Well, I think it's pretty clear where I stand. I don't believe that any machine has invented anything. But if we are not clear about what we mean by terms like invention, conception, and autonomous, then we will continue to be plagued by credulity and ambiguity. Currently, the notion is being granted more credibility than it deserves. While Patent Office may feel bound to accept assertions of inventorship at face value, even if this means rejecting applications, perhaps they should not. Maybe they should be asking more questions about the process of invention and seeking out the identity of a human inventor. It should go without saying that outside the application process, bodies such as WIPO should be exercising greater skepticism than they appear to be. Nonetheless, AI and machine learning do present some real challenges for patent law and practice. Does the availability of powerful tools that embody knowledge of huge quantities of information increase the range of what should be considered obvious and within the grasp of the non-inventive person skilled in the art? Does the classical patent bargain of exclusivity in exchange for disclosure require more than just a detailed written description in the case of AI and machine learning? These are the more immediate questions that we are only beginning to grapple with.